Sir, I go to sleep at 8 o'clock every night, sir. It's just the 10 o'clock ones, and I get my 5 o'clock one first thing in the morning, Your Honor. Oh, they just told me about this last week in pretrial over there, and they said that I have a 45-day miss.
From the 15th of November, you have been skipping tests. You have been to this court.
I go to sleep at 10 o'clock, and I still did the ones later on when I would wake up, and they told me this just last week, Your Honor. I swear to God. I swear on everything I love.
You know.
Please give me a chance, Your Honor.
Testing schedule is, and I've given you one pass after the other. He goes with you.
I'm here on behalf of Mr. Naylor this morning with Mr. Jones, Your Honor.
Come up, Mr. Jones.
Mr. Naylor is in Cancun until Monday next week, Judge, so he's not available this morning.
I understand.
So I'm kind of filling in. I have had a chance to look at this violation report regarding missed blows. I'm assuming that's our issue here today. Spoken with Mr. Jones about that. Pressed upon him the need for perfection here.
This is no tolerance. Absolutely no tolerance, because we've had one issue after the other. Testing positive for here, doing that over there. We've literally let you go over and over and over. And there's absolutely no excuse for the missed blows. How many missed blows do we have?
It says 19, Your Honor. Within that 7 or 8. But Judge, I would ask, if possible, as I'm not the lead on this case, and I know Dustin has had history with the court and Mr. Jones here on this case, if you would consider holding on the consideration of this matter until he returns on Tuesday of next week. So that
I'm sorry, Ben, I can't. I have to know. You have to know that we mean business. I'm not here to toy with you and play games with you. Know what the expectation is in this court. You've been with me for as long as we've had. You're over there.
Because I have a cold, Your Honor. It's cold weather. I apologize, sir. Can I please speak on the breathalyzer?
No. You know what the expectation is. You have 19 missed tests. That's it. I'm sorry, Ben, I can't. You're here in his stead. You're a capable and outstanding lawyer. I have the utmost respect for you, but 19 missed tests are 19 missed tests. And I've been telling him since the absolute beginning, there's just no tolerance.
Please,
No.
But to his credit, Your Honor, we have no positive UAs. He's been here on weekly UAs, so there's no indication that he's using this to obfuscate for alcohol.
Sleep early, man.
Test, and he is blowing outside the window, so we don't know what he's doing.
Oh my God, sir, I go to sleep at 8 o'clock every night, sir. It's just the 10 o'clock ones, and I get my 5 o'clock one first thing in the morning, Your Honor.
And you come here and you ask.
Oh, they just told me about this last week in pretrial over there, and they said that I have a 45-day miss.
You have 19 missed blows, dude. Covering the camera.
Please, Honor. I will do anything. I'll even go on that drug ankle monitor. I'll do anything, Your Honor. I'm really trying here. I swear to God, I will do anything you want me to do if you just please let me stay free. I swear to God, Your Honor, I'm really trying here. Please, Your Honor. It's just I don't even drink.
From the 15th of November, you have been skipping tests. You have been to this court.
I go to sleep at 10 o'clock, and I still did the ones later on when I would wake up, and they told me this just last week, Your Honor. I swear to God. I swear on everything I love.
You know.
Please give me a chance, Your Honor.
Testing schedule is, and I've given you one pass after the other. He goes with you. No.
Oh my God.
Your Honor, may we just...
Buckle up, guys. Today we are going to witness a tense courtroom showdown over repeated probation violations. The defendant pleads desperately, citing his sleep schedule and missed tests, while the judge lays down the law with zero tolerance. We see the clash of desperation versus authority as prior missed tests and positive drug results set the stage for serious consequences. The intensity builds as a possibility of a new bond is raised, leaving everyone on edge.
Discuss setting a new bond for...
Of course.
Oh my gosh. Why? Please, I'm trying to do everything.
Goes with you.
Oh my gosh.
Bond is at 5,001 now because of the prior violations. I will now set it at 10,002. I'm sorry, Ben, but he's tested positive literally over and over and over. He continues to test positive for marijuana. When I've told him to stop, he's tested positive for opiates. He's tested positive for this. Now he's skipping blows. Are you he has obscured the camera as well?
It's not necessarily that he's obscured the camera, but it's too dark to view. It doesn't mean that like there's.
It's the same thing. If we can't see you in the camera,
Yes, sir.
then you're fooling. And I'm done with the fooling. That's it. I know that Dustin's gonna be pissed, but I mean, I've got it in black and white. And Dustin knows that it's no tolerance.
Consider 7502, Judge Barnes.
Okay, Ben. Okay, great. But he has to know that we mean business, man. If I let him go now, I'm enabling, and I'm not gonna do that. I can't, but fine, because. Fine. All right, 7502.
Visit PC, Your Honor. Have some questions.
Oh, you picked up a new case. I'm sorry, I'm just getting wind of this now. I didn't realize this. He just picked this up.
My client or the person?
Yeah, him. Picked up an interference 2 days ago.
That's what I'd like to revisit.
Yeah, of course. So you were on felony probation for a very serious case, evading arrest in a motor vehicle, which carries up to 10 years in prison. Now you've picked up a new case. Greg, I got to tell you that I don't know how much you know, but I have quite a bit of history with Mr. Zenon here. In fact, within the last 2.5 years, 1, 2, 3, 4, 5, 6, 7, 8, 9. Now he's on his 10th case, specifically an unlawful carrying of a weapon, another unlawful carrying of a weapon, another unlawful carrying of a weapon, another unlawful.
The conversation escalates as the judge details repeated positive tests and the obstruction of monitoring devices. The defense argues of compliance and good intentions, but the courtroom tension mounts with each revelation of prior violations. The judge emphasizes accountability, showing no sympathy, while the defendant's pleas grow more urgent, highlighting the high stakes and the pressure of the legal system bearing down.
Carrying a weapon, felony possession of marijuana, felony assault of a pregnant person. And I guess all that worked into a deal where he got on probation for an evading, and now we have.
Right, but all those cases were dismissed, correct, Your Honor? Okay,
Pursuant to the, I guess,
I understand.
that we literally had one after the
Understand.
other, like a rung on a step ladder, one after the other.
And-
So let's do probable cause.
Thank you, Your Honor.
You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. I just wanted to give you a heads up of how much history we have with Mr. Zenon, because it's a lot.
I appreciate that, Your Honor.
Sure.
But be that as it may,
I'm not going to hold, I've never will hold anything against him. So let's go.
On December 3rd, 2024, officers were dispatched to the HEB located at 4955 State Highway 6 regarding a disturbance in progress. Officers received 4 calls, all from witnesses who stated the defendant was arguing with and assaulting a female. While en route to the location, officers observed the couple at the intersection about 0.1 miles away from the HEB where the original call was
Observed what?
located. They saw the couple at the intersection.
Okay, they saw. Okay.
Yes, Judge. The defendant was uncooperative with officers. The defendant advised he and the complainant were involved in a verbal altercation and stated he threatened her, saying he would slap her. When officers advised the defendant that he was in custody for an outstanding warrant, he got upset and began to yell. Officers located a clear plastic bag containing 3.6 grams of marijuana. The defendant refused to comply with officers' commands to sit down and would not place his legs and feet inside the vehicle. The defendant pushed back against the officer's hand with his chest when he attempted to help him into the vehicle, pushed his legs straight and applied force toward officer's hand in an attempt to stop him from placing his legs inside the vehicle, and then used the bottom of his foot against the bottom of the door frame to further resist. The defendant refused to speak with officers and would not cooperate with the investigation. All witnesses on scene heard the defendant threaten to hit CW, And another witness stated she observed the defendant push the complainant in the chest and face with 2 open hands. He does have an active felony warrant from the Fort Bend County Sheriff's Office for aggravated assault with a deadly weapon.
Now the focus shifts to a new case involving felony probation and repeated unlawful actions. The courtroom dives into the defendant's criminal history, uncovering a pattern of weapons offenses and assault. The observer sees a rising storm of legal consequences as the judge reviews the prior cases and the defendant probation, painting a picture of someone on the edge of serious prison time. Every statement tightens attention.
He has an open ag assault somewhere else too?
In Fort Bend County, Judge.
My understanding is it's
And
an
it was
older
open
case.
warrant at that time?
Yes, Judge.
May I respond to all this, Your Honor?
Sure, please.
Where's the interference? Okay.
Well, they're putting him in a car and he's like going
How-
blank.
It's not interference with public duties. If they're sitting there saying they have a marijuana charge they could have done, is it a resisting? Maybe, but it's not an interference with the public duties. They said he didn't talk. He doesn't have to talk to them. Like, and they're,
I understand
and
that.
they're a 0.1 mile away from the location
So
for what?
Well, okay, I get that, but so we've got a disturbance at HEB. Cops go there,
Okay.
they start to talk to him, and I guess at that point says, hey, man, I'm gonna slap her. So at that point, I mean, that's what we have,
Okay.
right? Mr. Zenon, there's always 2 sides to the story. I get it. This is just probable cause. It doesn't mean that you're guilty of this offense. It's just probable cause. That in and of itself, is it enough to continue an investigation? And it is, because it's a potential terroristic threat, right? So they have enough to go forward to investigate. They start investigating, and then they find that you have a felony open warrant. And then they find there was something else was there another warrant that you said?
No, it's the aggravated assault, but Judge, I also would like to point out that
But
as
they end
part-
up putting him in the car. And at that point, he basically just goes blank like this for them being unable to effectuate an arrest.
And Judge,
I don't think that's an interference.
I don't. I mean, I think the intent of the law within itself is that if you're interfering with their investigation for something else. He did not interfere with anything.
Hold on, let's read the code. Let's read it, because, I mean, there's no better way. Let's read it.
Hold on.
I'll give you, All right, hold on. Let's pull up the code.
Intake could have taken some other things, but
Well, certainly, they could have
Okay.
taken a whole myriad of, I mean, you're lucky they didn't charge you with assault of a peace officer. There's a whole host of other charges that they could have put on, you know? If,
but they didn't
Hit.
they took the one that I do not believe applies here.
let's read the code.
Okay.
Let's see what the code says, because, you know, there's multiple.
Officers recount a December 3rd incident describing verbal threats, resistance to arrest, and marijuana possession. Witness accounts and officer testimony underscore the defendant's defiance. From a third-party view, this section reveals the real-life dangers and chaos in policing while highlighting procedural standards of probable cause. The courtroom drama peaks as the law and human behavior collide in front of the judge.
Multiple ways that a charge can, you know, that you can charge someone with facts, right? There's multiple ways that can, it's 3815. Okay, you ready? A person commits an offense if the person with criminal negligence interrupts, disrupts, impedes, or otherwise interferes with, number 1, a peace officer while the peace officer is performing a duty or exercising authority imposed or granted by law. 2, a person who is employed to provide emergency medical services, a firefighter. Number 3, for an animal under supervision. Now, so I guess it's a person, it interrupts, disrupts, impedes, or otherwise interferes with, number 1, a peace officer while the peace officer is performing a duty or exercising authority imposed or granted by law.
That is the vaguest thing I've ever heard in my life. I mean, come on.
It is. I agree
Okay,
with
so
you.
the cop can claim anything is interfering with public duties. I mean, constitutionally, that is the vaguest thing I've ever heard of.
Judge, that's the statute, that's the penal code.
You'll find no argument with me, right? It is pretty vague.
Yeah.
It is.
He's got bigger issues. I mean, they should have taken the other charges, my whole point. I mean,
But he's disrupting the officer while he's trying to discharge a duty, right? The officer's trying to arrest him and put him in the car, and he's not letting him do it.
I mean, that's assuming they even had the right to do that. I mean, he's 0.1
It's an
miles
open
away.
felony warrant.
They didn't even know about the warrant. They didn't know about the warrant till after. So, I mean, that comes after all of this.
They're saying, go ahead. I didn't even give you a chance to talk.
No, you're okay,
Please.
Judge. They were investigating the assault, Judge, is what or the threat that he admitted to making. So it was an active investigation, and then when they were detaining him, he was resisting arrest, is what it seems like. And that's why it was charged with interference with public servant.
And there were also 4 911 calls that were made about this couple arguing. I mean, that's what they were investigating.
And the witnesses all
They
described.
put him,
the
I guess,
defendant.
did they put him under arrest at the time when he said that he was making that threat?
And with being.
I mean, did they
0.11
have?
The defense and prosecution debate whether the defendant's actions constitute interference with public duties or merely resisting arrest. The judge scrutinizes a vague statute, evaluating intent and legal definitions. Observing this, we see the nuanced tension between law interpretation and enforcement. Each argument escalates suspense, with the courtroom balancing on legal precision and human unpredictability.
Did they have the authority to arrest at that time? Right?
So I think it was during their investigation, the defendant admitted to threatening, that he would slap Miss Clark.
And it's at that point they start to put him under arrest?
At that point, they ran him through the NCIC and they found that there was an active warrant, and then they informed him that he was in custody.
Okay, then that's a resisting from what they're using to say he's pushing back or
But
pushing.
remember,
That's
I
a
mean,
resist.
it-
That's not
it
interference
could
with
be-
public duties.
But it could be that a set of facts can be multiple charges, right? So it could be resisting, but it could also theoretically be interfering with what he's trying to effectuate with, which is an arrest. It's a duty that he's performing. He's performing the duty of an arrest.
But again, it's vague. If the officer didn't put in the report, he's not saying in the dim summary, you are under arrest.
Well, I mean, it's,
Okay, well, I mean, but so.
I mean,
this
we
is-
don't know. I mean,
Okay, I'm just saying.
know if he says he's under arrest, but I mean, damn, it's all but clear.
I mean, this is.
We also don't have the offense report
We
yet,
don't
I
Judge.
don't
That's
care.
where
I
he
mean,
was in
but
the
I think that
process.
there's enough, he's under, he places him in custody, right? He's going to arrest him, starts putting him in the car, and dude goes plank.
I know, but I don't have the.
I,
video.
I've
I mean, I
shared the
think that-
videos with.
remember-
You're right, I haven't had a chance.
Guys, this is a very low burden. This is probable cause. This is not beyond a reasonable doubt, Beyond a reasonable doubt is a different standard. This is just to see if there's enough to go forward. And according to this, you're disrupting, allegedly, you're impeding, and you're otherwise interfering with him trying to arrest you and putting you in the car. A person can interfere with duties in multiple ways. It's not just one way. Like you go in there and someone else tries to stop an arrest from happening. I don't know. I think that there's enough.
Whisper to me because I want to know what you're about to say.
And if you want time, you guys can go back and talk.
Okay, well, I gotta say.
3 times to search me.
Can I have a moment to look at the video? He's telling me a whole separate fact pattern.
But I need to give them time to be able to look at it too. I mean, it's noon. Why don't we do this? Why don't we roll it to Monday and we can, I'll find it now. We can reapproach Monday morning or tomorrow even. And if you find, if you find a completely set of different facts than to what they're saying on video, I'm all ears. I'm always all ears. I'm always willing to rehear probable cause at any time. I mean, it's not.
Discussion turns to probable cause, arrest procedures, and the defendant's physical resistance. The judge provides a candid, almost personal insight into the consequences of choices and influences in life. From the observer's perspective, this is a rare moment of the court addressing human behavior alongside legal responsibility, blending suspense with moral reflection. The defendant faces the weight of both the law and the judge's scrutiny.
Did they have the authority to arrest at that time? Right?
So I think it was during their investigation, the defendant admitted to threatening, that he would slap Miss Clark.
And it's at that point they start to put him under arrest?
At that point, they ran him through the NCIC and they found that there was an active warrant, and then they informed him that he was in custody.
Okay, then that's a resisting from what they're using to say he's pushing back or
But
pushing.
remember,
That's
I
a
mean,
resist.
it-
That's not
it
interference
could
with
be-
public duties.
But it could be that a set of facts can be multiple charges, right? So it could be resisting, but it could also theoretically be interfering with what he's trying to effectuate with, which is an arrest. It's a duty that he's performing. He's performing the duty of an arrest.
But again, it's vague. If the officer didn't put in the report, he's not saying in the dim summary, you are under arrest.
Well, I mean, it's.
Okay, well, I mean, but so.
I mean,
this
we
is-
don't know. I mean,
Okay, I'm just saying.
know if he says he's under arrest, but I mean, damn, it's all but clear.
I mean, this is.
We also
And
don't
yes.
have the offense report
We
yet.
don't
I
Judge.
don't
Offense
care.
report,
I
he
mean,
was in the
but I think that
process.
there's enough, he's under, he places him in custody, right? He's going to arrest him, starts putting him in the car, and dude goes plank.
I know, but I don't have the
Three
video.
times.
I've
I mean, I
shared the
think that-
videos with.
remember-
You're right, I haven't had a chance.
Guys, this is a very low burden. This is probable cause. This is not beyond a reasonable doubt, you know? Beyond a reasonable doubt is a different standard. This is just to see if there's enough to go forward. And according to this, you're disrupting, allegedly, you're impeding, and you're otherwise interfering with him trying to arrest you and putting you in the car. A person can interfere with duties in multiple ways. It's not just one way. Like you go in there and someone else tries to stop an arrest from happening. I don't know. I think that there's enough.
Whisper to me because I want to know what you're about to say.
And if you want.
As the session concludes, the judge sets a timeline for video review and reconvening, maintaining suspense over the outcome. Everyone is left awaiting the final determination of probable cause. From an outside perspective, the courtroom drama lingers, a reminder of the delicate balance between law, procedure, and personal accountability. Like the video, subscribe to the channel, and we'll see you in the next video.